everybody, and good afternoon if you're with us from the East Coast, and otherwise from wherever you're tuning in. Very glad that you have chosen to spend the next half hour with us. It is April, and we are moving indeed more deeply into spring, although here in New York City, you might not know it. The Mets game, the team I root for, got moved to a 4 o'clock start so people don't freeze in the stands at 7 o'clock when it was scheduled. So it is still not quite spring in its fullest yet, but certainly there's a lot happening at every time of year, as you know, and that's why we're grateful you tune in. And so we want to give you value in the 30 minutes, and I would love, Sophie, if you could advance to the next slide so I can tell folks what is ahead. What I will be covering is the budget process, which is ongoing. I will tell you in more detail what I mean by that. And then immediately thereafter, Dan Carosa and Jayla Paul will be with us, each for the first time on the program. They sit respectively in Buffalo and in Rochester, and they're both intellectual property attorneys who are coming together to tell us about some interesting issues regarding patent and trademark pendency. Frank Mayer, who's been on the program many times, and we're grateful for that, is back with us from Albany, and he will provide guidance on employment issues involving out-of-state telecommuters. He approaches it from his broad business law perspective, as well as his deep understanding of tax. And then I will close things out at 12:30 if all goes according to plan. Of course, throughout, we look forward to your questions. Don't hesitate to enter information into the Q&A at the bottom of your screen, and we will do our best to answer everything that we can in real time. But if Sophie would advance the next slide, I'll get going with my presentation. And so what we are looking at right now is a slide that I covered in many respects a couple of weeks ago, but its issues and really the submatter on it has evolved to a degree, and I want to give you the update. We don't have a signed budget yet because there is still ongoing negotiation as between the governor and the Senate and the Assembly. What we do know is that we have extender bills that have been passed, most recently one that keeps the government running through tomorrow. And essentially, we need those because otherwise, folks in government won't get paid and, essential services won't get performed. Something that we've seen before in New York State, and that can be done indefinitely until we have a signed budget. But the hope with legislators back in Albany right now is that we'll have a deal done by tomorrow. That may or may not happen, though. We will find out more. If it doesn't get done by later this week, there may be a much broader wait before we ultimately see a budget signed into law. And that's because we're about to roll into the Easter holiday, the Passover holiday. There are school closures, and the legislature is not expecting to be back during that period. And so if it doesn't get done this week, it could be a little while. And some of the issues that have percolated that are on the table now, according to various news outlets, it seems that the governor is interested, among other issues, in looking at how the lieutenant governor is elected in New York State. As has been earlier reported, current Lieutenant Governor Antonio Delgado will not be running for re-election, and there have been other lieutenant governors historically, not only who haven't run for re-election, but who have had differences of opinion with the governor, not just Hochul, but those that preceded her. And so the governor, in this instance, is looking to see whether legislation could be, or language could be incorporated into the budget bill that would essentially connect both the gubernatorial election and the lieutenant governor onto one unified ballot, as opposed to essentially running on two separate lines at the same time as they do right now. And that would have some effect in terms of ensuring that the ticket is more united. And if in the governor's view that goes forward, I think that would be something she would be very pleased with. It would take further constitutional activity for that to be formalized. It wouldn't just be approved by way of the budget. There'd be more to do, but it would be a start if that happened. But that's now on the table, according again to contemporary reporting. Additionally, what remains out there are issues around criminal justice policy, and in specific, there are lots of conversations underway about discovery laws. There are relating questions around mask bans, as I think we've talked about on this program before. There are complicated issues between proponents of free speech and expression versus those who are interested in ensuring that individuals are not in any way obscured for public safety reasons. And those two camps, as it were, we're in some level of conflict right now. And that's another issue that is being worked through in the budget negotiations. Exactly where that lands is, frankly, anyone's guess. We have a sense that cell phones in schools and the ban during the day is something that's getting traction. So that is likely to be in the budget at the end of the day, whenever this budget is ultimately approved and signed into law. We don't expect, though, that those inflation rebate checks will go forward in the form that the governor had originally proposed. There's a lot of discussion as well still about involuntary commitment. As I mentioned in previous presentations, some of the concerns have arisen in connection with issues of public safety, whether in New York City subways or otherwise. And that's getting continued attention as we move toward a conclusion of the negotiations. There are lots of other issues that remain in play that I will quickly note, including the MCO tax, which is being counted on in the budget as it had been before. What we don't truly know is what will happen if in the end, sometime during the summer, there are larger federal-driven budget cuts, which could happen. Certainly, it's been rumored. And if that does happen, the budget will need to be recast. The current budget is counting on federal monies being generally as we know them to be presently. But of course, there's been a lot of activity around federal budget cuts in the first weeks of the administration of President Trump. I'll also note that still outside of the budget itself is the Consumer-Directed Personal Assistance Program, although there's been a lot of activity in that space over these last few days. The program, of course, was supposed to transition fully by April 1st, according to last year's budget, which functions as statute. That hasn't happened. There are delays. There are courts involved, both federal and state. Actually, in the last week, in the last couple of days, the current Health and Human Services Secretary, Robert F. Kennedy Jr., has indicated that the federal government will be looking into the program. So exactly where that lands is still very much uncertain, but there isn't formal language in the budget concerning it, as some had thought might be a means of resolving some of the outstanding issues. MTA financing is also not squarely in the budget, but interestingly, the New York Times is reporting that per litigation, it has been essentially revealed that federal and state negotiations have led to the extension of congestion pricing in New York City, where I'm speaking with you from, at least through the fall, which would mean a significant chunk of the budget that is dependent on congestion pricing will at least be stable through the fall. We'll see how that all goes. But for now, those are the open issues. There may be a deal as soon as tomorrow. There may not be. We don't know yet, but we will keep all of you apprised. And it's our pledge that you have the best information as soon as we know it. I'll be back with you hosting next week on the 15th as well, and I'll certainly be updating all of you then. But with that, let me move to our next presenters. And I thank you all for taking the time to hear me out on what's going on with the state budget negotiations. And if Sophie, you could move to the next slide, please, I'd appreciate it. Thank you. We have two presenters with us. Each is new to the program, and we're delighted that they can be with us. As I mentioned in my introductory remarks, Dan and Jayla are both within our intellectual property practice. Dan sits in Buffalo, Jayla sits in Rochester. They work together in lots of ways, including on some research that they put forth in an information memo that they're going to help you understand here on the webinar as well. There's some really interesting issues around patents and trademark that are part of their day-to-day that they thought you should all know about. Even if you're not rushing to get a patent sewn up every day and that's not your workplace, we hope that just by learning and being more fully aware of the intellectual property issues that may attend to the various workplaces that are present here among our audience, you'll have that much more understanding and appreciation for both the work that Dan and Jayla do, and if there are issues in your own house, as it were, that you didn't realize you had, but we can help you with. We're here to do that. But without further ado, let me turn it over to Dan and Jayla, both of whom, again, are new to the program, but we're delighted to have them, and we, of course, look forward to having them back. The floor is both of yours, and please go ahead. Thank you so much for presenting together.
Good afternoon, everyone. Thank you, Gabe, for the introduction. My name is Jayla. Again, I'm an associate in the Rochester office. And today, Dan and I will be discussing practical tips to shorten patent and trademark pendency at the United States Patent and Trademark Office, also known as the USPTO. Next slide, please. So the USPTO is an agency under the Department of Commerce. It substantively examines both patent and trademark applications. Patent examination, it's time sensitive and requires a search and analysis of prior patents, academic articles, product literature, etc., to evaluate both for novelty and non-obviousness. Similarly, trademark examination involves a searching process to search for potentially conflicting trademarks, essentially evaluating distinctiveness. And over the course of 2024, 700,000 new patent and trademark applications were filed. Next slide, please. Regarding pendency trends, there are two types of pendency. First is the first office action pendency. This is the average time from filing to receiving an initial rejection or allowance. And then total pendency is the average time from filing to the final disposition of the application. So that would be either a patent or trademark is issued or abandoned. The average time from filing a patent to receiving the first action from the PTO has risen 50% from 14 to 21 months in only 5 years. Total pendency has risen by 3 months in the same period. Similarly, for trademarks, first office action pendency is about 6 months. Total pendency is 12 months, and we have also seen an increase within the past 5 years as well. Next slide, please. So the USPTO has implemented some measures to reduce pendency. Some of these include ensuring that patents are routed to examiners with the correct technical backgrounds, the introduction of new tools to streamline the examining process. So for example, searching tools, and also the implementation of using artificial intelligence to help with searching. They have also hired more personnel, so 500 new patent examiners and 56 trademark examining attorneys have been hired since October 2024. There have been pay raise incentives for current examiners and also extended working hours for schedule flexibility. And lastly, they have optimized the Trademark Academy training program for new trademark examiners. So I will turn it over to Dan now to discuss the effects of these measures.
Thank you, Jayla. Next slide, please. All right, so as Jayla just talked about, the efforts the USPTO has taken to try to reduce pendency, these efforts have actually yielded some positive results. So, in both 2020, for both patents and trademarks, pendency decreased in terms of the first time to first office action. So regarding patents, the time to first office action dropped from 20.5 months to 19.19. And for trademarks, the time to first office action dropped from 8.5 months to a little over 6 months. Next slide, please. So as I think many are aware, the Trump administration has taken a number of efforts to try to reduce government spending. And this is, threatened to hinder some of the progress that the USPTO has made. So these efforts, in the form of, a federal hiring freeze, as well as the, overall federal employee return to office program. Um, so patent and trademark examiners have been mostly remote well before the COVID-19 pandemic. I speak to patent and trademark examiners regularly, and they're all over the country, from coast to coast, not just in, Alexandria, Virginia, where the patent office is based. Um, so, the fact that trademark and patent examiners can be anywhere, across the country is a, real perk in terms of recruiting and retention. Um, and, even if these examiners, all return to the office, the USPTO doesn't have enough office space currently to accommodate them. As a, potential warning sign regarding pendency, the first action patent pendency has increased, almost a full month from December 2024 to February 2025. Next slide, please. So, with all this in mind, the kind of general uncertainty regarding the status of the Patent Trademark Office, there are a number of tips that an applicant can take to reduce application pendency. So, a couple of things we recommend generally, both filing early and responding promptly. Filing early in the process, making sure that, when you first approach us or, your patent or trademark attorney to prepare an application, having all your ducks in a row in terms of, what you're filing for, the technology, the trademark, the goods and services associated with the trademark, having that all ready so we can, work as quickly as we can to prepare an application and sort of, get in front of the queue for the buildup of applications that's likely to happen as we progress through, and then responding promptly. Most responses in both the patent and trademark world are due within 3 to 6 months of the action being issued, that being a rejection or some sort of notice regarding formalities. So responding promptly can significantly cut down the time in terms of prosecution. We do our best to try to get out an initial reporting of any office action out to the client in the first couple of days. And then from there, working with the clients, working with your patent attorney, trademark attorney, to form a strategy as quickly as possible can be very advantageous to cut down that pendency. Some specific advice regarding patents and trademarks. Converting provisional applications early can be a real option to cut down that pendency. So a provisional patent application is a placeholder application that needs to be converted to a full application within 1 year of filing. It basically allows you to get a filing date on file with the patent office without having to provide all the details and pay the fees required to a full application. Given the fact that we may see increased pendency, filing for that 1 year deadline may be advantageous, especially, if you have all of your technical details aligned, you want to proceed with the full application. Filing, at the 6 or 9 month date before you wait that entire 1 year period can be, advantageous in getting in a more advantageous position in the queue of patents to be examined. Scheduling examiner reviews can be very advantageous. And this goes for trademarks as well. We highly encourage our clients to authorize us to speak with examiners directly whenever we face a rejection. This just ensures that there's no misunderstandings when we prepare a written response. It also allows us a chance to pitch in an informal way, potential arguments or amendments that we could use to, potentially achieve an allowance. It also, prevents us from making an argument that maybe the examiner won't exactly understand, or maybe will not, exactly address the concerns the examiner has. You can also consider prioritized applications. There are a few different types of prioritized applications, from track 1 applications to petitions to make special. These are available in specific circumstances and may not be applicable to everybody, but something to consider. And lastly, in terms of trademarks, a key piece of advice we have is ensuring accuracy regarding trademarks, goods, and services, as well as confirming that specimens of use meet USPTO requirements. These are two things you can address during the application process, making sure the goods and services conform with the manual of goods and services that the trademark office provides. This will ensure that the examiner won't object to the goods and services. And if they do, we can always give the examiner a call to try to straighten it out without requiring a written response. Similarly, in order to get a trademark registration in the US, we need to provide a specimen of use showing that the mark is actually being used in commerce in relation to the goods and services listed on the application. And so the USPTO has been cracking down the past few years in terms of specimens, mainly due to a large influx of potentially fraudulent applications from overseas. And they've become much more critical of our specimens and making sure that they conform to USPTO guidelines. So these are just some tips that we have in order to make sure that that the pendency is minimized and that we get your patent trademark application through as quickly as possible. And so with that, I'll turn it back over to Gabe.
Thank you so much, Dan and Jayla. Really terrific. It's a lot of information, particularly for those who don't work in the patent and trademark spaces. So if any of you has questions, if this is led to light bulbs turning on, as it were, please reach out to them. They are absolutely available to give you guidance and to talk it through more deeply. In the interim, though, let me turn to our next and last speaker for the program. And that is, if you go forward, that's great. That is Frank Mayer, who's a member in our Albany office. And Frank has been on the program many times, and we are grateful that he is back. Today, Frank is going to look at employment of out-of-state telecommuters by New York State employers. It's an issue that continues to sometimes be vexing. The standards are not always obvious, and Frank is here to untangle them. So Frank, thank you so much for taking this time, as always, and the floor is yours.
Thank you, Gabe. We'll untangle as much of this as we can in the 12 minutes or so that we have. So let's get to it. So as employers, we all know it's great to be able to expand our talent pool by reaching beyond the borders of New York State, but that comes with a number of challenges and compliance obligations that sometimes we're not always aware of, employers are not always aware of. Today, we're going to talk a little bit about employer registration, business registration, income sales and other taxes and applicable exemptions, and New York State withholding taxes, all of which need to be looked at when determining whether we want to employ employees working out of state. So if you take nothing away from this today, take this with you, is that wages are generally subject to taxation, withholding, and reporting in the jurisdiction where the services are actually performed, regardless of the location of the employer, the service recipient, or the source of payment. So that means that if a New York employer has someone working in Connecticut or Pennsylvania, that's where they need to register, withhold income taxes, and provide unemployment insurance, workers' compensation, and other state-specific lawfully required employee benefits. So that means, for example, that if you have a person working in Pennsylvania, you don't withhold New York PFL or provide New York unemployment insurance or workers' comp, because those jurisdictions are going to be looking for compliant policies and registrations in their jurisdiction. If an unemployment claim is filed, it's going to be filed or in the jurisdiction where the employee is working. And New York is not going to deal with an unemployment claim filed by a telecommuter from Pennsylvania, for example. So we want to be sure that we're registered and ready for those types of things. So another issue to deal with beyond just registering as an employer are some of the tax issues. Now, this audience probably consists of organizations that are tax exempt and organizations that are for-profit businesses. So the different requirements, but all important. So registration as an employer in a state, the topic we just spoke about briefly, may be considered to create nexus or a taxable presence in the state for corporate or business income tax purposes. For the for-profit folks on the phone, that may mean the requirement to file a corporate income tax in the state and apportion some of the income away from New York to that jurisdiction. And so that's not necessarily a bad thing, but it's just more of a compliance lift. And for those of us who are tax exempt entities, know that oftentimes there needs to be a filing for an exemption from corporate income taxes in a state where a telecommuter is working for us. And sometimes tax exempt organizations may need to file a tax return to report their unrelated business income. In other words, that's income that's not specific related to the organization's exempt purpose, even if that activity subsidizes the charitable mission or not-for-profit mission of the exempt organization. And so some states require filing of a return only if unrelated business income is present for not-for-profits, and other states don't require any type of filing. So that needs to be a state-by-state analysis to keep compliant on these sort of ancillary issues to employing telecommuters out of state. Tax exempt entities would need to file typically an exemption from sales tax in the out-of-state jurisdiction if they intend to make purchases in that jurisdiction. And also tax exempt entities may often need to register with the Charities Bureau if they are such that they intend to make charitable solicitations, within the state. And one other issue, licensed professionals, let's say psychologists, nurses, physicians, rendering services out of state to New York patients or service recipients are going to likely need to be registered as a professional to practice in the state where they're rendering services, even if they're sitting at their kitchen table providing services to New York service recipients or patients. And so beyond all of that, organizations typically will need to qualify to do business in the state. So we've already talked about employer registration in the state. We've talked about registering the business for taxes and the like, or exemption from taxes and the like. But now we're talking about qualification to do business. Are you authorized to do business in the state? Has the state determined that your in-state activities, even if it's a person working at their kitchen table, may be sufficient to require qualification to do business? Failure to qualify may prevent an entity from bringing a lawsuit because it transacted business in the state without a certificate of authority, but in most cases, an organization is allowed to defend a lawsuit brought by someone else against it in the out-of-state jurisdiction. States typically impose penalties on foreign corporations and LLCs that transact business without qualifying or registering. In a few cases, states have the ability to impose penalties on officers or directors of unregistered organizations. Now, the trouble is that there's not a lot of authority out there in the state statutes of what constitutes qualifying to do business. Most of the statutes read similarly, and they provide only negative assurance with regard to what doesn't constitute doing business. Not all that helpful. Only a few states that I've seen actually have published authority, like California and New Jersey, for example, that say if you have a single person telecommuting from the state, that requires you to register to do business. And typically registering to do business generally requires a filing of an income tax return if you weren't otherwise required to do so, just because of the fact that you registered to do business. So it might be a zero return. So things that you might not expect go beyond the scope of, just registering, to have someone render services at home, require businesses to do many more things. Now, of course, if that's not enough fun, New York State has to get its piece of the action too. And New York is what's called a convenience rule state, or I like to call it an inconvenience rule state, because this concept called the New York Convenience Rule, requiring employment of out-of-state telecommuters, requiring those employers to withhold income taxes on employees that work out of state is anything but convenient, and in some cases can lead to double taxation, state taxation, for which there may not be a relief mechanism for the out-of-state employee. Although a few states do allow credits for state taxes paid to New York, but that's more the exception than the rule. And so this is all based on a case called Huckabee versus the Division of Tax Appeals. It's a 2005 New York Court of Appeals case. It's the highest court in New York State, as a reminder. And in Huckabee, a computer programmer worked in Tennessee, spent 75% of his time working in Tennessee, and the other 25% of his time working at home. And the Huckabee court articulated that the taxation of 100% of the income of a non-resident who spends a trivial amount of time working in New York is not the issue, although 25% is hardly trivial. So this leaves open the question that what level of contact can a person working as a non-resident out of state would need to have in order for New York to cause the individual to be subject to New York taxation. In Mr. Huckabee's case, it was 25%. But, the question is, what about, 1 month? What about 10 days? What about 1 day? And I suspect New York is careful on what tax cases it wants to bring against out-of-state telecommuters for a single day or for 3 or 4 days. But that does leave the employer exposed if withholding doesn't occur on those wages. Now, following this decision in Huckabee in 2006, and it's still the law of the land, if you will, in New York. New York issued a TSBM -65 Cap I on May 15th, 2006. If anyone would like a copy, I'll send it to you. And basically citing what its criteria is to determine if an employee is working out of state for their own convenience, as opposed to the necessity of the employer. Person's working out of state for their own convenience, then all of that income is going to be subject to taxation, regardless of how much, if they spend, I guess, at least 1 day working in New York. So basically, if you're working out of state for your own convenience, not the necessity of the employer, then you're going to be taxed by New York on your out of state wages, even though you're going to be taxed in your home state on the wages. Now, to avoid the New York state taxation, the office of the telecommuter out of state has to be considered a bona fide employer office. And so you have to meet either a primary factor or at least 4 of 6 secondary factors and 3 of 10 ancillary factors. Otherwise, again, the employer is required to withhold New York state taxes. So the primary factor, which pretty much nobody meets, means that the home office must be near specialized facilities. For example, in the TSBM we're talking about, the state cites an example where an engineer who works for an auto company with an office in Manhattan, the engineer lives in Michigan and his job is to test new cars on a racetrack or test track, because there's no such track available in New York City for him to do his job. And as a result, the tax department says in this hypothetical that the individual isn't going to be subject to New York tax because he's really there out of necessity. Another example I could think of, but not cited in the TSBM, is that if you have a New York company that is a house painting organization, they paint houses for a living, they're contractors. If they send their employees from New York and they hire people in New Jersey to paint houses in New Jersey, it's pretty hard to paint houses in New Jersey from a New York office. So it might be arguable that they're in New Jersey working by necessity as to not convenience. So there's a couple of hypotheticals to put this in perspective. Alternatively, because few people meet these examples, you can meet either 4 of the 6 secondary factors and 3 of the 10 ancillary factors. And given the limited amount of time I have, I'll just run through a few of those. So the secondary factors of the 4 of the 6 include the home office is required as a condition of employment. You could state that in an employment agreement. The employer has a bona fide business purpose for the employee's out-of-state home office location. So if you have an engineer working on several projects in the out-of-state jurisdiction, maybe you could justify based on that. The employee performs some or more of his core duties or her core duties there at the home office out of state. Now that's pretty much expected. If you have a stockbroker requiring purchases and doing purchases and sales from home, that's fine. But if the person's just there reading emails in business pubs on the weekend, not so much. Another example would be of the secondary factors. The employee meets or deals with clients or customers at the home office on a regular basis. Again, this kind of shows how old this publication is that New York stands behind when it contemplates meeting with people in person at the home office when so many people meet virtually, like we are today. Another example would be the employer does not provide designated office space. So if the employer closed a portion of the office off because they want to reduce the cost of rent when the employee comes to New York, they have to provide a cubicle, a visitor's cubicle for the employee to work from. That would be one criteria. And another of the 6 secondary factors would be that the employer pays for substantially all of the expenses of the home office, meaning 80% or more in the words of New York State. So the employer would have to pay a prorated amount of insurance, fair value of rent and so forth, which is, let's say, typically unusual, particularly when someone is there because they want to be there, not because the employer requires them to there. And I know we have limited time, so I'm not going to zip through the 10 other factors. We've got to meet 3 of those, but a couple of those just to give you a flavor. The employee maintains a separate telephone line for the home office. Who does that anymore? Many people don't even have landlines. The employer's home office address and phone number are listed on the business letterhead of the employer. Also improbable. And the home, I like this one. The employee uses a specific area of the home exclusively to conduct business of the employer and separate from the living area. And if your house is anything like mine, the area that I designate as my home office, I go in there and I typically trip over kids' toys or some other object that someone has put there. So nobody uses a portion of their house solely for business purpose and no other purpose in the real world. Another example might be that the office is covered by a business insurance policy, and also the employee may not be an officer of the company. So that's about half of them. So many times employees who want to get this exclusion from New York withholding try to make this argument to the employer. Sometimes the employer wants to make the argument, and I've seen very few cases where that's been successfully argued. So again, what we're looking at is that basically the employer is going to have to withhold taxes in both jurisdictions, register for taxes, and try to register to do business as well. So I know we're running short of time here, so I want to wrap it up. If there are any questions, I'd be happy to take those and help you if I can. Thank you.
Frank, thank you. We thank as well all of you who've stayed with us. We know we're a bit over time today. We hope the information was valuable, and I am glad that you could stay with us all the way to the end. Frank's contact information is there on the slide presented. I know as well there are a couple of questions that came through the chat, so Frank will be able to attend to those offline. And I will be back with you, as I mentioned earlier, a week from today on the 15th. I very much look forward to seeing all of you. If Sophie, you'd go to the next slide and go one more still, you'll find the contact information. Thank you, Sophie, for all of the presenters, including Dan and Jayla. And we look forward to hearing from you if you have questions. In the meanwhile, wishing all of you a terrific week. We thank you for your continued loyalty to the program. We're always glad to have you with us. We'll see you soon.